You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome, listeners, to another episode of People, Places, Planet. I'm your host, Sebastian Duque Rios, and I'm excited today to continue our Explain series where we break down the United States' fundamental environmental law. Today, we'll be talking about the Endangered Species Act, or the ESA. And I'd like to welcome our three wonderful guests, Patrick Parenteau, Jake Lee, and David Wilcove. Why don't you go ahead and briefly introduce yourselves? Pat, maybe we can start with you.
So I'm now an emeritus professor of law at Vermont Law Graduate School, where I've been teaching for the last 35 years and a long career before that, which I won't bore you with.
Hi, I'm David Wilcove. I'm a professor at Princeton University in the Department of Ecology and Evolutionary Biology and in the School of Public and International Affairs. And my research interests center around how do we protect biodiversity in an increasingly hot, crowded, and hungry world. And prior to joining the faculty here, I spent about 16 years working for the Nature Conservancy, the Wilderness Society, and the Environmental Defense Fund in Washington, D.C.
Great. Jake, want to go ahead and close us off?
So I've spent most of my career working on endangered species issues for environmental groups, for the federal government, and for industry. 2 months ago, I returned to Defenders Wildlife as the VP for Conservation Policy. But immediately before that, I worked at the U.S. Fish and Wildlife Service as the career head of the office that oversees the Endangered Species Act, the Marine Mammal Protection Act, and several other federal laws. And then right before that, I worked in the Biden administration for EPA, focusing on how to protect endangered species from pesticides.
Thank you all. It's an absolute pleasure to have you here with me today.
I'm excited for this conversation. Thank you.
Good to be with this distinguished group.
To get us started, Pat, could you start by giving us a quick primer on the Endangered Species Act? Why was it created and the history behind it?
Right. So it was Richard Nixon, and he summoned the nations of the world to Washington, D.C. in 1973 to craft what became the Convention on International Trade in Endangered Species, so flora and fauna, CITES, as we now call it. And at that time, he called on Congress to deliver to him by the end of the year, 1973, a law to protect endangered species in the United States, but also to cooperate with other nations of the world in protecting biodiversity globally. And Congress did that remarkably and overwhelmingly. So the 1973 Endangered Species Act, which is the act that we're going to be discussing today, had two prior iterations in the 1960s. But those laws were primarily about information exchange with the states and others and creating the list, which became the list of threatened and endangered species in 1966. But it's the 1973 law that's the primary law that we have today, and it was incredibly bipartisan. Republicans and Democrats on both sides were very strong advocates of the 1973 Act. It passed unanimously in the Senate. It passed with only 12 dissenting votes in the House, a remarkable accomplishment when you think about it. And so it was addressing human-caused threats of extinction. Extinction is obviously a natural process. In fact, 99% of all species that ever existed are extinct. So it wasn't a question of stopping extinction itself. It was stopping the human-caused rate of extinction, which, of course, was accelerating. The threats that Congress was aware of at the time, the big one was DDT, the poison that was affecting birds of prey like the bald eagle, the peregrine falcon, the brown pelican, but also overexploitation of species like the American alligator. It was on the brink of extinction, largely through hunting and poaching and trapping. So those were the origins of the law. Here's the structure. So you start with what's the purpose of the law, and remarkably, again, it's to conserve the ecosystems upon which threatened and endangered species depend. So it starts right away with an ecological focus, and that's because the primary author is Dr. Lee Talbot, who was the senior scientist with the Council on Environmental Quality. And Lee being an ecologist, framed the law around science. So it is classically a science-based law. And it's a law that focuses on something other than humans, right? That's one of the distinguishing characteristics of this law in all of environmental law. It's about preservation of the ecological process, the evolutionary process, and other biological diversity aspects of sound ecological management. So some of the key terms, recovery. The law doesn't actually define recovery. It talks about recovery plans, but it doesn't define the term. The courts have seized on the definition of conserve in the law, which means the use of all methods and procedures to bring species to the point where the special protections of the Endangered Species Act are no longer required. It's kind of an awkward way of defining the ultimate objective of the act, which is not only to prevent species from going extinct, but to recover them, right? So that they don't have to be listed. The other concept is critical habitat. This is a very controversial term, but it's defined simply as essential to the conservation of species. It applies to both occupied areas, that is, areas where the species is still there, occupying, but also unoccupied areas, which was also another critical and controversial concept. Listing species is solely a biological or scientific consideration. When it comes to critical habitat, the law does require consideration of economic effects. It doesn't create a formal cost-benefit analysis like some laws do, but it does require consideration of economics.
Thank you, Patrick, for providing that overview. And before we get into how the Act classifies species, David, could you give us a sense of some of the biggest threats to species in the U.S.?
Let's take a look at what the Endangered Species Act is up against. In other words, what are the threats to species in the United States today? And I'm actually going to give you some statistics that come from a recent paper put out by scientists at Defenders of Wildlife, Jake's organization, which shows that habitat alteration and destruction, whether on land, rivers, in the sea, that affects about 81% of our endangered species. Overexploitation, either for pets or for products or for some other reason where people capture, kill, or capture and keep a species, that affects about 32%. Invasive species, that is, harm caused by non-native species, things like rats or goats that can get into ecosystems and do a lot of damage, that affects about 53% of our endangered species. Climate change seems to have the potential to affect about 72%, and pollution affects about 34%. Those numbers add up to much more than 100% because most endangered species have more than one threat. But basically, the Endangered Species Act has to deal with habitat loss, climate change, invasive species, pollution, and overexploitation. And I want to focus for a moment on this issue of habitat loss because it is the most pervasive threat in terms of affecting the greatest number of species. And the ability of the Endangered Species Act to address this number one threat hinges on whether the Endangered Species Act, by prohibiting harm to endangered species, means it can prevent habitat destruction. And I will let my colleagues with legal training explain why that has become probably the biggest controversy and threat to the functioning of the Endangered Species Act quite recently.
Yeah, so I've got a long history with critical habitat designations and litigating it. It's true that the Fish and Wildlife Service in particular has resisted designating critical habitat for the reasons that they claim it's redundant, that the listing of the species is enough to protect them. That's really not true, and the courts have not accepted that argument ever. What the courts have said, and I mentioned this earlier, is that the designation of critical habitat, because it's backed up with the Section 7 prohibition, that agencies can't take actions that will adversely modify designated critical habitat. The courts have said the critical habitat function is separate from the listing function that's separate from the jeopardy function, that's separate from the take prohibition. It is peculiarly adapted to recovery. And so courts, not necessarily effectively, but consistently have said agencies have a responsibility both to designate critical habitat, even when they don't think it's prudent or because it's very controversial and not politically popular. But the point is that the courts say when it comes to enforcing protection for critical habitat, designation has a very distinctive role to play. There's debate about what quantum of impact on critical habitat would trigger the adverse modification prohibition, right? Is every acre of critical habitat sacrosanct? Probably not. Is 10% loss of critical habitat adverse modification? I would probably be arguing, yes, it is. But there's reason to debate that point, and I suppose there's reason to say that's a problem with the way the critical habitat designation has been implemented over time. Maybe there's a better way to protect habitat than critical habitat. I would be open to that. But, unless and until you have a better provision of the law that's backed up with enforceability of some kind, I think that would be a loss for species.
Jake, did you want to add something there?
Yeah, let me add more context to this, which is, as Pat said, critical habitat designations can be incredibly controversial. And we oftentimes see actually a lot of public comments opposing critical habitat. I want to put a little bit of perspective on this because this has been a question that's been bugging a lot of people who work on ESA for many, many years. So almost exactly 10 years ago, actually, a colleague and I looked at every Section 7 consultation that the Fish and Wildlife Service has conducted over basically an 8-year period from 2008 through 2015. And so that was actually 88,290 Section 7 consultations. So roughly 10,000 consultations every single year that the Fish and Wildlife Service carries out. And we oftentimes hear about the threats of jeopardy, adverse modification, and so forth. What we found is that across almost 90,000 consultations, there was one jeopardy biological opinion at the end of the day. Fish and Wildlife Service found jeopardy once across almost 90,000 consultations. And adverse modification is basically the same number. It's almost non-existent. So that paper raises a lot of questions around how Section 7 is implemented. On the one hand, you can look at it and say, actually, Section 7 isn't really stopping projects. The service isn't calling jeopardy and just flat out saying you can't proceed because there are no ways to mitigate those impacts. On the other hand, one could look at that data and say that maybe the agencies are being too lax in how they find jeopardy or adverse modification. The service spends lots of money, sometimes millions of dollars a year on critical habitat designations, and yet it basically never calls adverse modification. So what is the point of putting a whole bunch of lines on the map when there isn't follow through from a regulatory standpoint? I frankly don't know what the correct interpretation is. I think there's truth in each of those interpretations, depending on the species and the part of the country you're looking at. But I did want to provide that perspective because when I first learned about the ESA in law school, I thought the Fish and Wildlife Service was calling jeopardy and adverse modification left and right, that it was stopping all these projects. And the reality is actually the complete opposite.
All right. So before we move on too much, I think we touched on some of the ESA's general goals. But I wanted to talk a little bit more about this classification of endangered versus threatened and what's the scientific determination behind that.
The Endangered Species Act's definitions of these terms are pretty straightforward. Endangered is any species which is in danger of extinction throughout all or a significant portion of its range. And a threatened species is any species which is likely to become an endangered species within the foreseeable future throughout all or a significant portion of its range. What that means in practice can be a little bit more complicated, but essentially we know that as the populations of species decline, as the number of remaining individuals shrinks, the chances of that species disappearing completely increase greatly. Effectively, what one does is you look to see what are the threats. Is it habitat destruction? Is it overhunting? Is it pollution? Climate change? How rapidly is the species declining? And how many individuals are left? And how are they distributed around the landscape? And if you find that the population is declining very rapidly, or that there aren't that many individuals left, then you can build a good case for a species being endangered or threatened. Threatened, suggesting that the situation isn't as urgent, that you've got a little bit more flexibility to address those threats, but not so much flexibility that you could ignore them entirely. And the law allows for a slightly more relaxed approach to protecting threatened species, a little bit more permissive than for protecting endangered species. By the way, we call it the Endangered Species Act, and most people use that term, oh, that's an endangered species, to encompass both endangered and the threatened species that are protected under the law.
Great. Anyone else have anything they want to add?
Well, one is the category of distinct population segment. This is not a scientific concept, as I think David would agree, but it is a political concept. It was designed to deal with species that are transboundary. If you think about the wolf is not endangered in Canada. It was endangered in the United States. So the distinct population segment technique was designed to protect those species that might be abundant in another country, but were not in the United States. That concept has evolved, and the services are now using the distinct population segment category to actually subdivide populations. If you think wolf, grizzly bear, spotted owl, these are different population segments of a species, sometimes subspecies. And the services are using the DPS category to actually delist individual populations. And that's another highly controversial area of the law. But DPS is something for people to be aware of.
So if I can follow up on that, the law as written allows you to protect species. The California condor, the blue whale. It allows you to protect subspecies, which are geographically separate and somewhat distinct varieties of a given species. So, for example, a little brown bird in the West, the California towhee, very common. But the California towhee, a race that lives in a small part of California, quite rare. And as Pat noted, in the case of vertebrates, you can protect distinct populations. And there is some debate about the wisdom of having such a broad range of things that can be protected. You'll find people who say that we should really focus on protecting full, distinct species like the California condor or the blue whale, and others who argue that to achieve the overall goals of the Act, protecting ecosystems, we should indeed protect the subspecies and the distinct populations of species.
I'll also add that it's notable roughly 70% of all US listed species are plants and invertebrates. And so they don't qualify for this distinct population segment listing. And I think a lot of people don't realize that, right? When you think of an endangered species, you oftentimes think of bald eagles, alligators, condors, and so forth. But the bulk of listed species are not those types of species.
Thank you, everyone. That's a really helpful foundation for understanding how species are categorized and the range of challenges that the Act covers. Pat, maybe you can take us a little deeper into how the ESA was written to work in practice. What are its main provisions and how do they fit together?
Section 4 is the provision that deals with listing and critical habitat designations primarily. There's a couple of other things. And notably here, the listing process does not rely just on government-initiated listings. It creates the rights of citizens to petition for listing. And that has actually become the central mechanism by which many of the species that are on the list, and there's over 2,000 now, get on the list through citizen-initiated petitions. And the reason for that is the law creates very strict deadlines for processing petitions, for moving forward with decisions as to whether a species should be listed, and if so, in which category, and then also a requirement that critical habitat be designated to the extent practicable, as the law says, at the same time as species is listed. So the Section 4 listing critical habitat process is the central procedural mechanism, the gateway, if you will, for species to get the protections that the law requires. And it's backed up by the citizen suit provision, which I'll mention just at the end of this. So it's not just that citizens can ask the agencies to list species. And the agencies we're talking about: Fish and Wildlife Service in the Department of Interior, National Oceanic Atmospheric Administration, and the National Marine Fisheries Service within the Department of Commerce. Those are the primary agencies for administering the law. And the citizen suit provision is designed to require those agencies to act within specified timeframes. And if they don't, citizens can go to court and enforce that. The other aspect of Section 4 to mention is what's called the 4D rules dealing with threatened species. This is another very controversial subject of many, as I keep saying, that we're dealing with right now. But the point is, Congress made a distinction between endangered species. When they're listed, they're automatically protected not only from actions by the federal government, but also actions by others, whether they are federal, non-federal, state, tribal, private, actions that, quote, take a species. So Section 4D is set up to say for threatened species, the option is to develop a special rule designed to both prohibit actions that would take a species, but also authorize actions that can go forward that the agencies have determined would not result in a take. Final thing on Section 4, very important now, experimental populations. So this is a different category of designation of species that allows a whole lot more flexibility. And the primary example of that is the gray wolf, which without the experimental population category, the gray wolf recovery in the Yellowstone would never have taken place. So experimental populations are going to become even more important in the era of climate change because species are being forced out of their historic range. The conditions of those ranges and habitat are changing dramatically, and experimental populations are probably going to be needed as a technique to deal with that. Section 7 is the other major provision we have to talk about. It turns out it's the teeth, really, of the law. Section 7 applies to the federal government and all federal agencies and their actions, whether authorized, funded, or carried out, that may affect a listed species. And there are two kinds of consultations, formal and informal. The formal consultation is the one that requires the production of a biological opinion, and this would be by either Fish and Wildlife Service or NOAA, and that opinion is designed to assess in a very comprehensive way cumulative impact on a species that could result in jeopardy. The concept of jeopardy largely relates to the survival of a species. That's how this terminology has evolved over time. The statute itself doesn't say that. It doesn't say that jeopardy is only about survival, but the agencies have gravitated around that concept when they make determinations as to whether a federal action is likely to jeopardize a species. The other prohibition of Section 7 relates to critical habitat. And what it says is that agency actions cannot destroy or adversely modify designated critical habitat. So adversely modify is actually a much lower standard than jeopardy. And so the courts have distinguished adverse modification from jeopardy based on whether the adverse modification impairs recovery. So jeopardy, survival, adverse modification, recovery. And then, of course, Section 7 also authorizes the issuance of something called an incidental take statement by the agency, which takes us to Section 9. Section 9 is the other major operative provision of the law, which prohibits the take of species. Take is broadly defined: kill, wound, capture, or attempt to do any of those, plus two very new terms in federal environmental law. So the prohibition on actions that would harm a species and harass a species. Harass actually appears in other laws like the Marine Mammal Protection Act. But in the Endangered Species Act in Section 9, the concept of harm is hugely controversial. Again, I'll have to defer any further discussion of that. But it does relate to actions that impact habitat and that thereby indirectly affect a take of species. And so this whole concept of Section 9 because it applies to everyone, because it applies to the private sector, to private landowners, is obviously one that's a highly sensitive and debated part of the Endangered Species Act. Moving on, Section 10 then creates the incidental take permit program. This came into being in the 1982 amendments to the law, and it was specifically designed to deal with the problem that private landowners were experiencing because the courts were ruling that they were subject to the take prohibition, which is backed up by both civil and criminal penalties, right? So a serious piece of law. And so Congress created the incidental take permit program to authorize actions that would otherwise be prohibited and result in liability, right? So then you come to Section 11. That's the citizen suit provision. It's also the provision that lays out the penalties, both civil and criminal, of the law. And the citizen suit provision, of course, is controversial. But as long as citizens can establish standing, they have a very, very wide and formidable array of judicial actions that can be brought to both force agencies to do mandatory duties like listing, like designation of critical habitat, but also to sue agencies for not consulting, for not avoiding jeopardy or adverse modification, and challenging the decisions of the agencies that say that these actions will not result in jeopardy or adverse modification. So the citizen suit provision is a driving mechanism under the Endangered Species Act for sure. In fact, the law of endangered species that's been developed through the courts is largely the result of the citizen suit provision.
And Jake, maybe if you want to take us actually through a brief summary of what that process would look like of listing a species. I know we kind of got in a sense for it, but from your experience in the Fish and Wildlife Service, what does that process look like?
Sure. A small handful of milestones is the best way to think about that process. As Pat said earlier, one avenue for listing is through a petition submitted by a citizen or an environmental organization. I think it's very noteworthy that since the 1990s, there have been almost no endangered species listings that the service has initiated on its own. Almost every single listing has been the result of a petition submitted by a small handful of nonprofit organizations that specialize in endangered species conservation. So that's the starting point for the listing process. And the service has 90 days to decide whether that petition has enough information to warrant further review. And if it does, then it has this 12-month deadline to determine whether the species, in fact, meets the definition of a threatened or endangered species. That's the definition that Pat and David mentioned earlier. And if the species does meet this 12-month positive finding, then the service has to propose a rule to list the species, and then it has to finalize that rule. So throughout this entire process, there are opportunities for public comment. And oftentimes the public submits a lot of information about a proposed rule or to inform a 12-month process. I think about the monarch butterfly proposed listing, which I worked on when I was at the Fish and Wildlife Service. We got, I think, somewhere in the neighborhood of tens of thousands of public comments about whether to list a monarch butterfly. So there are some petitions that generate a tremendous amount of public interest. And then there are other petitions that generate very little public interest, right? You can think of a plant that's found on a 1-acre piece of property. Very few people know about that plant, and species like that oftentimes don't generate a whole bunch of public attention.
That's a really important point because some of the most endangered species, in the sense of species that are likely to disappear very quickly unless they're protected, get very little public attention, very little notice because they are plants or insects or inconspicuous salamander. And the amount of hoopla associated with a given listing controversy is unrelated in most cases to exactly how rare that species is.
Just to build on that, one of the most difficult strategic questions in all of this is where to put the scarce money that you have for recovery of species, which species to really invest in. And that gets to questions of triage, a very controversial subject, but one that's hard to avoid. I mean, if you think about it, if there's a limited pot of money, are you going to spend it all on the highest profile species even ones that don't really have a realistic chance of recovery, if that can even be determined. And obviously, that's a very difficult thing to try to determine. But if you look at the way the money is spent under the Endangered Species Act, there's a fairly small number of species that gets the lion's share of the money. And there's a constant debate about, would we be doing better in recovering more species if we were more strategic in where we put the money that we have?
I'll actually put some numbers to this. So I was part of a big study about a decade ago where we looked at how federal agencies and state agencies spend money on ESA species. And what we found was that roughly 80% of all federal and state dollars are spent on 5% of listed species. And many of those species are Pacific salmon. And then some fairly expensive non-salmon species like red cockaded woodpeckers and several other fairly wide-ranging species. So there can be a pretty big disparity between the cost of conserving some of these really well-known species and then the cost of a plant or an invertebrate that's found on only a few acres.
When we're talking about Pacific salmon, none of those species, as in full species, are at any risk of extinction. What is at risk of extinction are particular populations that spawn in particular watersheds. And they're certainly worth protecting, but it's a very legitimate question whether it is worth devoting so much in the way of resources to those populations that much of the remarkable diversity of life in the United States is ignored.
This is a really interesting conversation, and I didn't know much about how funds are allocated for the specific recovery of species. And I think it touches on the point that we were talking about earlier of what the ESA says about recovery to begin with. David, did you want to touch a little more on that?
The Act defines recovery in very simple and clear language, which is it's to bring a species to the point where it no longer needs the protection of the Endangered Species Act. That is to say, it's able to thrive in the wild on its own without a great deal of human intervention. Classic example would be the peregrine falcon, once gone from much of the United States. Today, from my office in a building in central New Jersey, I can look out across the campus, and we have a tall tower that houses the math department. And on top of that, the building often are peregrine falcons. They've made a wonderful recovery. And there's not a lot we need to do now to protect them, other than make sure that people don't, for some reason, get in the habit of capturing them or killing them. However, we should be clear about two things. First, there are successes that fall short of recovery that are still really notable and worth celebrating. To keep with the bird example, the California condor. By the mid-1980s, there were no more than about 25 California condors left. And this is the largest flying bird in the United States, one of the largest flying birds in the world. Spectacular creature. And the Fish and Wildlife Service made the very risky decision to bring all of the remaining condors into captivity because it was clear that they were not persisting in the wild. And by starting a captive breeding program, by reducing the threats in the wild, which included a lot of poisoning from lead shot used by hunters, and by releasing birds back into the wild in areas where they felt they could thrive, today the population of the California condor is about 560 individuals, about 360 in the wild, and a couple hundred that are retained in captivity for captive breeding. That is a spectacular success. But the California condor is a long way from being at the point where we just wouldn't worry about it anymore. And in fact, I think it's the case that the majority of our endangered species will never reach the point where we don't have to look out for them, where we don't have to manage their habitats properly, alleviate some of their threats. And in that sense, they're always going to be under our care. I wish that weren't the case, but that's just a biological reality given how pervasive the threats are. But in my mind, it's no reason to write off those species or to consider the act a failure because it can't get them to the point where they can be just forgotten about. It's a reflection of how much people have changed the planet that most of our endangered species are going to require a little bit of tender, loving care on our part if they are going to last for the indefinite future.
So, what David is just describing is what we call conservation dependent species. And here's the problem with the structure of the law. It's an either or proposition right now. You're either listed and subject to full protection and all the bells and whistles, or nothing is what we currently have. And that's probably not the proper way to think about the problem that David has just described for us. And I can think of many species that fit his definition of perpetual care. One of my own favorite that I've got a lot of history with is the whooping crane, right? The whooping crane, its population now in the wild is back up to over 300. It was down to 23 at one point. But it's hard to believe, even though we're trying to introduce additional experimental populations of whooping cranes in the eastern part of the United States, that it will ever be eligible for complete delisting and no protection at all, or only the protection that individual states can provide in a 3,000-mile corridor of migration. Very difficult challenges for biodiversity management and a need, frankly, for some adjustment in the Endangered Species Act that takes account of what David has been describing, but in a way that still protects species, still provides stewardship responsibility for them, but doesn't just stick with the current protocol that we have, which is so controversial.
If I could make an analogy, there's a lot of attention now about the Louvre Museum in the face of the spectacular jewel robbery. One way to think about some of these species is that they are so rare and special that, like great works of art, they need to be protected and watched over in perpetuity. No one is faulting the Louvre for having so many security guards or putting the jewels in a glass case and depriving people of a chance to touch them and feel them. To the contrary, there's a recognition that they're irreplaceable, that they are vulnerable, and they need to be protected very carefully for the indefinite future.
I love that analogy, David. It really captures the sense of care and vigilance that recovery requires. And it sets up an important question. We've talked about recovery in broad terms, but what does that look like day to day? Jake, maybe you can talk about the kinds of actions or programs that fall under the ESA and how the service approaches things like critical habitat designations.
So as we've heard earlier, I think about the activities under the ESA as falling to two broad categories. One is regulating activities that harm endangered species, and the other is promoting activities that help them recover. For example, restoring habitat, reintroducing species back into the wild. So it's not about preventing people from doing bad things. It's about encouraging people to do good things. And we've talked a lot about how to minimize the impacts of activities that harm endangered species. I think it's worth talking more about activities that can promote recovery. Let me give an example. I think somewhere in the neighborhood of 2/3 of all US listed species depend on private lands. And yet there's nothing a private landowner needs to do to help move the needle forward for a species recovery. They can do nothing and allow invasive weeds, pollution, and all these other things to chip away at the species. And the ESA doesn't really require that landowner to do anything proactive to address the situation. That is sort of a death sentence for a lot of listed species. So ever since, I'd say, the early 1990s, the Fish and Wildlife Service has spent a lot of time and money trying to think through, okay, how can we change that situation? How can we encourage private landowners and states to proactively do more to help recover species? And so there are a number of programs that help with this approach. For example, for many years, the Fish and Wildlife Service had something called the Safe Harbor Agreements, which are basically agreements to say, private landowner, if you promise to do something good for endangered species on your property, we won't penalize you in the future if you decide to do something else with that property. And now you suddenly have all these endangered species that you grew right on your property. So that approach was instrumental to the expansion of populations for the red-cockaded woodpecker and a number of other species that rely on private lands. And in the past 5-10 years, the service has done even more. It's worked with USDA on programs funded under the Farm Bill, such as Working Lands for Wildlife, that try to work with farmers and others to manage agricultural fields for endangered species. The Department of Defense has done quite a bit of proactive work to conserve the many listed species on their property. So those are some examples of a large number of activities after a species is listed. That's not about permitting.
Couple of other points on that, because I think it's really important to talk about how do we improve the track record of recovery for the species. There actually are a number of policies that the Fish and Wildlife Service and NOAA have adopted. They started with when Secretary Babbitt was Secretary of Interior, and they're aimed at facilitating landowner cooperation. One, in addition to the safe harbor provision that Jake just mentioned, is the no surprises policy, one that I had initial concerns about, but over time, I think I've come to agree that it's necessary. And what that basically says is once an agreement has been reached on an incidental take permit with a habitat conservation plan, the landowner that agrees to that can't be subject to any more stringent requirements as time goes forward. And obviously, for landowners, particularly major landowners, think timber companies, for example, that kind of predictability, stability is incredibly important. So the no surprises policy is very important. Another one that I'll mention is candidate conservation agreements with assurance. What it basically says is if the relevant parties, and this could be states, private landowners, some combination, want to agree on a conservation strategy to avoid the listing of a species, if you can, in fact, develop an agreement and a plan with not just vague aspirational goals, but hard and fast agreements, accountability and transparency to avoid listing and avoid all of the red tape, that can go a long way to advancing conservation in a more efficient way to get more support. And one final one is the service has also come up with mitigation habitat conservation banks. This is a concept that we were very familiar with in the wetlands context, pioneered by EPA and the Corps of Engineers under the Section 404 program of the Clean Water Act. It's another opportunity for landowners that want to invest in habitat restoration that Jake was talking about, can actually get credit for that. And they can use those credits when it comes to forestry or mining or real estate development, lots of different economic activities. That's a good outcome for species.
Great. Thank you all. Can you just provide a roadmap of what agencies are involved in the implementation, but also on the enforcement side, what kind of penalties can any violations face?
So for over 95% of listed species, it's actually the U.S. Fish and Wildlife Service that has the lead in overseeing. And for the remaining species, mostly marine species, it's NOAA Fisheries or National Marine Fisheries Service. I think of the services as really the conductor of an orchestra. The services themselves own very, very little land, and they also have very limited ability to directly manage land, right? Again, they don't own millions and millions of acres of property. So it's really up to other federal agencies, particularly land management agencies like the Forest Service, the National Park Service, Bureau of Land Management, Army Corps of Engineers, and so forth. It's up to states who own a lot of land. It's up to private landowners. For example, in the state of Georgia, 90-something% of all land is non-federal. So you're going to have to be in the business of working with private landowners in states if you want to make any real progress on endangered species conservation there. And it's also up to businesses. If we think about how many businesses own corridors, transmission lines, and other areas where you can restore species, a lot of the work on the ground is actually not in the direct ownership of the services. It's in the ownership of all of these other entities. So I think they are just as important when it comes to implementing the ESA. The services, again, they're sort of the conductor of the orchestra. They can provide guidance, they can provide direction about what to do on the ground, but it's really up to those landowners and managers to decide whether to do those things. So I think of the ESA as sort of all of the above. Everyone has to be involved for biodiversity conservation to succeed in the US. The other thing I'll mention about federal agencies is that the ESA does create this obligation for all federal agencies to use whatever authorities they have to help conserve listed species. So earlier, Pat talked about these Section 7 consultations. These are projects that federal agencies carry out, fund, or authorize. Oftentimes, these projects will create some type of harm to endangered species. And so if those were the only types of activities that federal agencies oversaw, we would actually see a chipping away of species recovery progress because you would only have activities that undermine species recovery and you would do nothing to compensate for that loss. That's why the ESA also creates this obligation I've been mentioning for all federal agencies to use their authorities to help conserve listed species. And the idea is that the balance of the bad activities and the beneficial activities would help move species closer to recovery. That's at least in theory how the ESA works. I'm chuckling a little bit because in reality, that has not been the case for a lot of federal agencies. This obligation to proactively help recover species hasn't been taken seriously by many agencies, and it's been very difficult to enforce this requirement in court. I know the services have tried several attempts to try to create incentives for federal agencies to do more, but there hasn't been the type of court case that allows an environmental group, for example, to bring an agency to court to say, you haven't been doing enough for an endangered species under this Section 7A1 of the ESA. So I think that's one way to think about all of the different players when it comes to ESA. Pat, I'll throw the question of enforcement and penalties to you.
Sure. There are two kinds of penalties. There's civil penalties. It's $25,000 per day per violation. And that would be for take primarily under Section 9. That applies to everyone, including state-owned lands and state permitting programs. There's a very famous case, Strahan versus Cox, which said that when the Commonwealth of Massachusetts issues permits for fishermen lobster pots with vertical lines entangling whales, that's a take of the whale. And the act of the state issuing a permit to allow that is a take. It's what's called vicarious liability. So enforcement is both through the agency's authority to issue civil penalties, but more importantly, for the citizens to bring enforcement actions against activities that would be covered by Section 9 take prohibition. The citizens don't get penalties under the Endangered Species Act, but they do get injunctive relief, which can result in significant costs being expended to both get an incidental take permit and, importantly, come up with a habitat conservation plan. So you have the civil penalties, you have the citizen suit provision enforcing the law, then the criminal penalties come into the focus. The term there that the statute uses is knowingly violate. So if you are guilty of knowingly violating the act, that can result in both misdemeanor and felony convictions. You don't see a lot of criminal prosecutions on the domestic side of the ESA. You do see a lot of citizen suit cases, including against entities like state agencies, like county agencies, like even tribal governments. You do see a lot of enforcement through that mechanism.
Like many of our US fundamental laws, this is a big law and a lot to cover, and I'm sure we could talk about it for hours. But I know we wanted to talk about recent developments. Are there any recent notable developments or rulemakings that you all would like to discuss?
I'll start with the loss of staff. The U.S. Fish and Wildlife Service has lost about a quarter of its staff since January 20th of this year. In 9 months, an agency that can barely keep up with many of its legal deadlines has almost overnight lost a quarter of its staff. This poses a fundamental change to how the Fish and Wildlife Service does its work, especially under the ESA, because I think it means that a lot more permits, a lot more listing decisions, and recovery plans and other ESA functions are going to be even slower than they were before. And when this administration is over and the next administration comes into place, I think it's going to be left with a complete mess. And folks on the outside, like us, can do a lot to help reimagine how Fish and Wildlife Service does its job. This unfortunately poses almost an existential crisis for the service. I know many of my colleagues back there have never seen morale worse. And that was before the shutdown, right? So now people don't know if they'll even have jobs or if they'll get paid when this is all over. In my mind, this is as bad as any change in rulemaking or any court decision because changes like this affect every function of the Fish and Wildlife Service and it affects culture. Culture is just as important as policy, in my opinion, working on ESA from within the agencies.
I'd like to elaborate on this issue of funding. Some colleagues and I recently published a paper where we looked at funding trends from about 1985 up to 2020 and beyond. And one of the things we found very striking is the number of species added to the endangered species list has grown steadily during that period. Yet, if we look at the amount of money that Congress allocates to the Fish and Wildlife Service to save those species, to recover them, and you adjust for inflation, you find that that amount has actually been decreasing. And what this means is the amount of money available per species to try to recover that species has been declining steadily. And that means, in essence, we're asking the Fish and Wildlife Service and other federal agencies to do more and more with less and less. And that is a recipe for failure in terms of species becoming extinct because they're not getting the attention they need, and a loss for the American people because, of course, once these species disappear, they are gone for good. So in addition to the cuts in staffing, you have to worry about a long-term trend in not giving the Act enough money to do the job it was intended to do. It's as though you built a hospital, put in all of this nice equipment, and then decided that you weren't going to hire doctors and nurses to work at the hospital. It's not going to do the job you wanted it to do.
I agree with my colleagues very strongly on both of those points on institutional capacity and funding. I think those are absolutely core requirements for any success that we might have under the Endangered Species Act. There are some policy changes in the works that are very troubling. In the first Trump administration, there were a number of proposals to repeal laws and policies, and many of those same ideas have come back in Trump's second term. The one that I think I'll focus on for now is the repeal of what's called the harm rule. I mentioned this earlier. In the definition of take, it includes the concept of harm. And again, with Secretary Babbitt during his tenure, the Department of Interior adopted a rule saying the term harm is distinctive from direct impacts on species, kill, wound, trap, export, etc. But it incorporates the idea of habitat loss and degradation of habitat that species depend on, frankly, whether it's designated critical or not. So the harm rule, which has been on the books now for 30 years, is proposed to be repealed by the Trump administration. And the consequences of that are really profound when you think about what we've been talking about, habitat loss being the primary driver of endangerment and extinction. To say that an action that would destroy a species' habitat doesn't harm it, that's pretty stark. The key Supreme Court decision on this whole issue is a case called Sweet Home versus Babbitt. Sweet Home being a community in Oregon that was drafted, frankly, by the timber industry to bring the lawsuit. And it upheld Secretary Babbitt's interpretation of harm, including habitat loss, by a 6-3 vote in the Supreme Court. But there was a very strong dissent from the late Justice Antonin Scalia. And of course, the court that we have now gravitates much more to the Scalia view of the world than perhaps the Justice Stevens view of the world. So we've got a different Supreme Court. We've now got a doctrine of jurisprudence from the Supreme Court saying the test for interpreting a term in a statute is, quote, the best reading of the term. And I worry that a proposal to repeal the harm rule that goes all the way to the Supreme Court, you might find a 5-vote majority for saying, well, the best reading of harm is not habitat loss. It really is the direct impact. So I don't know exactly how to forecast what's going to happen. I can say if the harm rule no longer protects habitat, that will be a serious loss for species protection.
I would just add, as a biologist, I can tell you that you destroy the habitat of a species, the individuals of that species, they will die as a result of that. You may not find their bodies, you may not see their deaths, but it is as destructive as shooting them or trapping them.
And I'll add that, so far we've talked a little bit about habitat conservation plans and some of these Section 10 agreements. A lot of the driver is the harm definition, because it can be very difficult to, as David just said, prove that there was a dead body of an endangered animal. But you can make that nexus to habitat loss resulting in actual injury or death much more easily. And that's a big reason why we have a lot of the habitat conservation we have under the ESA. It's through these big habitat conservation plans that are driven by the harm definition. So if that harm definition is gone, I think it fundamentally changes the ability of the ESA to do its most important job, which is to conserve habitat. I'll just offer 1 minute of final thoughts as I think about the current political situation and the next few years, and think about what the American public really wants from our elected officials. I hear a lot about the need for affordable clean energy, the need for affordable housing, for better transportation networks, for food that's affordable. And these are all great things, right? All of us depend on these benefits. And yet, many of these activities would impact endangered species. These are all examples of development. So I think a key over the next 5-10 years is to identify the areas that are the least impactful to endangered species for development. A lot of work can be done over the next few years to identify which species and habitats, for example, cannot be impacted at all because we don't know how to offset those impacts, and which types of impacts can be offset while still allowing the species to recover. If we don't figure out how to balance those competing needs, I'm actually afraid that we're not going to find solutions that work for species. So I think there's a lot of science and policy work that can be done over the next few years to get ahead of what I predict to be quite a bit of development.
When the public is polled about support for endangered species, it's wildly popular. I mean, it's in the 90 percentile constantly. So the public support is broad, but it's not deep, and it's not salient in the context of electoral politics. That's a big problem. Trying to prevent additional loss of habitat is obviously incredibly important, but maybe even more important is a large national commitment to restoring lost habitat. And sometimes it's expensive, and sometimes it's really not that expensive. But some kind of public-private partnership around a program of restoration, if we could somehow mobilize public support for that concept and get it embodied in law, that would be hugely beneficial.
Well, thank you both so much for those concluding thoughts. And thank you all for joining me today. I think this has been a really insightful conversation on the Endangered Species Act, and I think it comes at a really critical time. So thank you all for being here today.
My pleasure.
Thank you for your interest in this.
Thanks, Sebastian. Good to be with you, my colleagues.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.